Sunday, I know it's a easy day, but then I'll make it very interesting. I'll take you through the PowerPoint presentation on what is intellectual property rights from the point of a startup. The most important question I always face from a startup client is, sir, we don't know what intellectual property applies to us. How do we protect our intellectual property? How do we identify our intellectual property? What intellectual property should we register? How long can we retain the intellectual property? These are all the various questions that arises. But before I start this, I'd like to tell you a very small story. See, from 1970 to 2005, India's patent law only spoke of process patents, right? What we were doing, getting a drug from US, if it had 7 components, one for headache, one for sweating, one to control your temperature, another to control your what is called as bad stomach, fourth to stop your acidity. We used to bring something like that. And we adopted something called as a reverse engineering. We used to go from the bottom. Okay, there are 8 components in this. Yeah, India hai, har ek to sweat hoga, remove that. Temperature, yes, keep it. Next component, remove. So few of the components were removed. It was remodified and then was introduced in the market as maybe Crocin or Calpol or paracetamol, whatever it could be. This reverse engineering was putting the West in a very tight spot. The West used to say, look, we do all the inventions. To make a molecule, it takes 8 to 10 years. Then human trials take about 2 to 3 years. And by the time the whole thing comes to the shelf for sale, it is almost 12 to 15 years. You guys just come, pick it up, do reverse engineering, introduce it as a different product, and then you sell it in your country. At that time, NDA government was there. So the late lamented Mursoli Maran, he did a great job for us. I mean, in his last days, he in fact negotiated the entire WIPO agreement lying on his hospital bed. We said, all right, since there is a lot of pressure from the West, we will shift from the process patent to product patent. Right? Patents are now granted for products. Why I am talking about patents is one of the most premium IPR that gives you a monopoly for 20 years. You can stop the entire world from manufacturing a similar product or adopting a similar process. Then the Indian government said, all right, we'll think of shifting to the product patent. But what is the assurance that once when we shift, our markets won't be, throttled? Because after all, India has got a huge population and we need to take interest of the Indian population. Drugs had always been cheap in India. Then the West, the moment we said we are thinking about it, they knew it was a huge saving for them. They said, all right, you put forth your suggestions. So India said, all right, we'll get into the product patent, but on 3 conditions. 1, the West will not in any way control our drug prices. We will control our drug prices. If I want to sell Anacin at 1 paisa, I will sell it. You should not say anything. If I want to sell a compound of vildagliptin for blood pressure or sugar, at 20 paisa, I will sell it. You will not say anything. All right, that was accepted. Second, if the public health in India suffers at any stage, we will throw intellectual property out of the nearest window. We will not respect intellectual property. It may belong to any MNC. It may belong to any country. The West also agreed for it. And the third was a very important thing, and the city of Hyderabad has got a lot to do with regard to the third request, because we are also a major giant in pharmaceuticals. What we said is, look, out of the 100% requirement of AIDS retroviral drug in the world, you should give us a market of at least 65 to 70%. And we should be proud that India supplies almost 78% of the world's retroviral drug requirement. And most of it goes from Hyderabad. After having agreed to it, we shifted to the product patent regime. That story is to say how we kept the West under control. We migrated to a product patent regime. We didn't succumb to the price pressure. We didn't succumb to any other pressure from the West. I want to tell you one more story also. This is also important. How does intellectual property help a common man or a poor man in this country? Right? Laws are brought for the people. There was this very costly medicine called as Nexava. Right? It was being used for kidney cancer, and it was being manufactured only by Bayer. Bayer had a patent for it. They had a patent in India, worldwide patents they had. One of the conditions when you take a patent is you need to work your patent. That is, once you get the patent, you need to tell the government that I am working this patent. These are the number of sales I have been doing. This is how I have been working it out. Otherwise, your patent is liable to be revoked. Let me tell you a caveat. No intellectual property is permanent for you if you don't follow the rules. Your trademark can be rectified, removed from the register. Your patent can be revoked. You can simply overnight become being a patent holder. Overnight you may not be having a patent. Apart from revoking under patent, there is something called as compulsory licensing, which is much more. One of the conditions when we bargained with the West was also compulsory licensing. I will tell you what happened here. Then you will understand what compulsory licensing is. Bayer introduced this product, and it was only able to supply to 2% of the 8,842 patients who are suffering with kidney cancer in India. One of the conditions when you get a patent is you should work it out. That is, you should see that the supply is there. You should see the supply is on time. If your product is unique, you should also see that it is sold. You could have the price, but make it available. There was a complaint, there was a compulsory license proceeding initiated by NATCO, again an Hyderabad firm. NATCO had a lot of reasons, but the most important reason was that the supply of the drug was so very thin, there was so much of shortage of the drug that only the 0.5% of this 8,000 could even afford. The cost of the drug was in lakhs. Only 0.5% of the patients could afford. Then the controller of patents asked NATCO, all right, what is it that you want? NATCO said three things. First, we will manufacture the similar drug in India. And then we will sell it at what price? It was being sold at lakhs. Nexava by Bayer was being sold in lakhs. It could not be afforded. NATCO said, we will sell the drug at 8,880 rupees per month. Imagine what intellectual property can do. Then, NATCO also said, it's my citizens who are suffering, my countrymen suffering. So, for the first 1,500 patients who are suffering this disease and who are at an acute stage, we will supply it free of cost. That was compulsory licensing. The world was shocked. Let me tell you, this gentleman, the controller of patents, was one IAS officer. When he passed this order, the world was shocked. Can India do this? Are we issuing a compulsory license against multinational like Bayer and telling, look, We are going to breach your patent. I am going to give the rights to someone else in India. They are going to manufacture it and sell it at 8,880 rupees. At that time, I was in Hong Kong and I was attending a conference called an INTA. I am a committee member of that, International Trademark Association. You know the amount of criticism Indian lawyers face there? The amount of criticism. In one topic, table topic, when this issue got up, I proudly got up and I said, we stood by the promise to our people. You guys were unable to sell it, make it available at affordable price to a patient. We will do it. We have promised, we will do it. Now, it is a different aspect how many pharma companies have literally changed the sense of looking at a disease. According to me, sugar is not common for everyone. Sugar is independent to each person. It depends on his way of life, how he trains himself, how he takes care of his health. But what did the companies do when vildagliptin was brought in? They said whoever has got 110 has sugar. So they brought in an entire set of human beings into that. The next thing they did was not improving the efficacy of their medicine. What they simply did is they made 110 to 115. Another 20% came in. I openly tell this in all conventions or all this thing, that sugar and blood pressure is the greatest fraud that has been played by pharmaceutical companies on humanity. My senior was there, 80 years old, he was a sugar factory. His sugar readings were so high that when it was showed to some doctor in Bangalore, he told his daughter, you bring this guy wherever he is, bring this man, he will collapse with this sugar high. But nothing happened to him. He is like Honda advertisement, fill it, shut it, forget it. Still goes strong today. At 85 years, he appears in the court, argues, he has got the sanity to argue, he is legally sound. Now, having given you these two instances of how powerful you can, with your ability to what is called as, bargain, you can hold the West to a certain level, retain your integrity of products, retain your independence of products in this country. At the same time, tell the West, tell the MNCs, please behave yourself when you bring in a medicine to our country. Now I'll go through now as a startup, what do you exactly look at? Are you really ready to launch your product in the market? I would like to give 3 caveats at this stage. It will be in part of the slide, but then the timing is more important. No, caveat is a warning. Okay? We file caveat petitions in the courts, right? We give notice to the others and say, look, if you are filing a case against me, we tell the court, if he is filing a case against me, without hearing me, please don't pass any orders. That's a caveat. The first caveat is, there is a stage between the invention and the product taking a shape as either a patent, a trademark or a copyright. This gestation period is extremely important. This is where maximum seepage of information happens. I'll give you a very simple example. I constitute a team of about 5 people. I say, please build a bread toaster for me. The first guy is told, you design the bread toaster. Second guy is told, you write a source code for it that will run the system in such a way that the bread does not get burnt and it gets popped out the moment it is about to get burnt. The third guy, I tell him, you make the popping mechanism. Fourth guy, I tell him, you make the mechanical parts in it in such a way that it does not, affect the working of, heating up the bread. Now all these 4 guys sit together, they take paper, pen and then they start drawing. One guy draws the shape of the bread toaster, the other guy starts scripting the software, the other guy designs a VLSI, the workable, what is called as the systems that go into it, mechanical systems. Now each one has an idea in his head. Do you agree? Each one has an idea in his head. The guy who is designing doesn't know that the Design Act applies to it. The guy who is writing the script doesn't know that copyright applies to it. The guy who designed the VLSI doesn't know that the Printed Circuits Designs Layout Act applies to it. The guy who did the mechanical aspects of it doesn't know that patent applies to it. And the guy who is going to market it doesn't know trademark applies to it. How do you protect this information? It has not come to the paper, it is only on paper, there is no prototype. Each one has got a complete vision of what he is doing. Only purpose was integrating all of them and then creating a product. How do I protect this idea? It's only at the idea stage. Two things. That's what every startup has to follow. One, enter into a non-disclosure agreement with every inventor or every person contributing to your startup. Two, make it a point that it is kept as a trade secret till the product emerges. So this is the period when gestation of an idea has to take form of either patent, trademark or copyright. The second caveat, once you know Coca-Cola, right? Are you aware Coca-Cola does not have a patent for their formulation? It's a trade secret as on today. Trade secret is the characteristic of the group that is working on it to keep it as a secret. Okay? The moment you write something on paper, it's gone. So how Coca-Cola protects its trade secret of a formulation, no one knows. Similarly, most of the pharma companies I don't know how many of you people are working with the pharma company, but they have something called as a, one record book or a blue book where they write all the formulations, keep it in one safe place. Trade secret does not have a law in this country. It comes under the common law, under the Contract Act. Patent has got a law, Patent Act. Trademark Act has a law. Copyright has a law. Design Act has a law. Printed Circuits Designs Layout Act has a law. Geographical Indications has a law. Plant Varieties has a law. Farmers' Rights has a law. But two important intellectual properties in this country does not have a law. One is traditional knowledge. Second is trade secret. So the second caveat is, do not write, do not give lectures, do not post on a blog, do not put it on the digital medium for whatever reason it is. Keep it as a secret. Your first disqualification when you file a patent is a prior art. Prior art can be done from anything. Anything. There is a true incident that happened with the USPTO. There was a ship that came to one of the island nations in Gulf. It had a lot of sheep in it. Suddenly the ship developed a hole and the whole ship started sinking. Somehow they tried to manage to rescue some of the ship, but the rest of them went along with the ship. The water was getting murky and infected and all that. They wanted the ship to be salvaged. That island, that Gulf nation said, they floated a tender. They said, who can salvage the ship? So one French guy came down. He said, mine is only a prototype idea, but I can try it. They said, all right, try it. What he did, he took some plastic balls, filled in helium into it, put it inside the ship. Because of the buoyancy, the ship comes up, right? Then he thought, what a brilliant idea, why don't I file a patent application? He went ahead for a patent application, filed it. The moment you file a patent application, your application is examined by the controller by the examiner. He will issue you something called as a first examination report. He will say, you have made this claim. How is this claim this thing? Your invention is obvious, it is not non-obvious, it is not applicable for industry, it is no invention at all, there is already an invention on that, these are all the prior art. So many objections they will take. This guy managed to get over all the objections. One or two objections were left. He said, I want a personal hearing with you. All right, that day the examiner was going to the office, USPTO. He came down in his house, 2 floors, he came down for breakfast. Just look at it's a true incident that happened, it is reported. He was sitting in his breakfast table, he was thinking of what he has to do in this case. Opposite to him, his daughter was sitting and she had a comic of Donald Duck in her hand. You know, most of the comics have the future edition printed in the back, right? A future, this is going to come, this is going to come. So there was one small, very small photograph of Donald Duck trying to put some balls into a sunk boat, not a ship, boat, small boat, and then trying to retrieve it up. Examiner said, all right, I have the answer for it, give me the comic. He took it. They came for the hearing, they sat. All he did was put the comic in front of him. There is already a prior art. Tell me a good reason why I should give you a patent. This guy was not connected with the prior art at all, right? He didn't publish it, he didn't give it. But some comic gave out the idea that yes, a ship could be salvaged or a boat could be salvaged by a buoyancy method of filling plastic balls with gas and then bringing it up. So do not put it on a blog, don't talk about it, don't write articles. That's the second caveat. Third caveat, you can have a prototype. You can always have a prototype because prototype gives more clarity to the examiner. When you sit and argue before him, you say, sir, my claim that it's a cylindrical object with both ends closed and can be separated equally in the center is seen here. The second part of the 2 parts contains an electrical discharge unit, which is a battery, and then it leads the electricity power to a illuminating device, which is a bulb. You know how the claim is written? And that illuminating device gives out light. Yeah, I'll take your question, I'll come to that. Gives out light, and the light is so very straight that you can point it out to a particular object. Prototype can be there. Prototype always is it's better to have a prototype. The fourth caveat, do not commercialize your product till you file an application. Don't commercialize your product till you file an application. The fifth caveat, to many professors here, I always get this standard question from them. Sir, I am writing a thesis for my doctoral. How do I protect the idea that is there in it? Simple. File a provisional patent application and then submit your thesis in the college. First you file your provisional patent application. I'll tell you what are the types of patent applications that are there. So these 5 caveats, please remember, as a startup, don't do these mistakes. Mind you, once a patent is filed, it is published, it is examined, you cannot file a second patent on the same technology. That's gone, dead and gone, that's all. Now, before publishing you file the provisional. Nothing prevents you from filing a provisional before publishing. Yes. Provisional is done only for that purpose. I'll now come to the actual I'll answer your question. Then, like any other property rights, I'll leave the PPT. Copyright is mine. You can use it for study but not use it for explaining something. Or these are all the different types of intellectual property. Patents, industrial designs, trademarks, copyrights and related rights, trade secrets, layout designs for integrated circuit, protection of new plant variety and geographical indications. What may be necessary for startups is only the patent, copyright and the trademark and the design, of course, the design also. Why intellectual property? Why should I at all have intellectual property? Why are we talking so much of intellectual property? Why are we saying we need a patent? Why are we saying? These are the 4 important things. To provide incentive to the individual for a new creation. Provide due recognition to the creators and inventors. Ensuring material reward for intellectual property. Ensuring the availability of genuine and original products. If you get a patent for 20 years, it can be a retirement benefit, let me tell you. A good retirement benefit. unless you properly prosecute your patent, unless you properly see that your patent is used properly even by the licensee or assignee or whoever it is, or if they are unable to use it, sell your patent. There are lots of things that can happen. Then IPR is an asset of business.